I'd like to open those up for discussion in moving forward and trying to do this in a timely manner. The first we have discussed before, but again, I'd like to, open it back up. As I mentioned, Article 8 of the Charter, Department of Law, was the first that we went through and tackled. And one of the first questions is, shall the county attorney be allowed to represent other municipalities? As the charter is currently written, the county attorney is not able to represent other municipalities. And there are a number of municipalities that have indicated an interest in retaining our current county attorney to be their municipal counsel. So I want to open that up for discussion and engage the legislators here feeling on that. Legislator Wheeler.
I have a question. I know with some municipalities, the biggest issue has been conflict of interest. In the short tenure that I was on the Board of Supervisors, not only was there never a conflict of interest, but you did an exemplary job. Do you foresee that being an issue?
Yes.
The best barometer of that I can give you is that I haven't represented large numbers of other municipalities over the years, but there have been small numbers of them. In the 16 years prior to 2014 that I served as county attorney, there was never one instance where there was a problem. Could an instance develop? Yes, it's a possibility, but I think with 16 years having passed and there not having been an issue with it, I was disappointed to see the provision. This is my own outlook on it, perhaps, but in there, because I think it was unnecessary. Had there been recurring problems over the years, either with the county or with the other municipalities or both, I certainly could understand it. But to tell you the truth, at the end of 2013, I was really only representing one town and one village. That would be the town of Canajoharie and the village of Fort Johnson. The village of Fort Johnson I represented since I started practicing law 25 years ago. They're sitting there waiting patiently to find out how this thing is going to shake out, because they want to leave things the way they are. And I've taken a brief hiatus from doing things. That's my own outlook on it. It has never been a problem.
Can I follow up with one more quick question? If, for say, something was to arise, would you, how would you resolve that? Or would it be?
I'll tell you this. What has happened, everybody's aware that the position of county attorney, as it's presently constituted in Montgomery County, is a part-time position.
Right.
I maintain my own law practice. Right. There have been a couple of instances over the years where there have been conflicts where an individual client of mine, not a municipal, right, not a governmental client, but an individual property owner, something to that effect. When that occurs, I have had to step away from it and advise the both parties that situation exists. I don't think as long as you have a part-time county attorney that you're ever going to insulate the county completely from that potential situation. It's never escalated to the situation. To my knowledge, it has never escalated to the situation where the county has had to go out and hire somebody to stand in. I don't believe it has.
Thank you
but
so
but
much.
it has happened where there have been, at least in terms of working out a situation, a couple of times with private clients, not governments.
Thank you.
Yeah, I think a guy's got to be able to make a living, and I have no concerns about conflicts. Just My concern goes more toward meeting nights, and if there was conflict on meetings, where would.
If I may,
I don't know what it is, sorry.
somebody's answering for me. I would not take on, this is just me, I'm not gonna be here forever either. It's the position, it's not Doug Landon, but at the moment it is because that's where the recent history is. But I would not, neither of the municipalities that I was representing through the end of 2013 met on Tuesday nights, and I would certainly not take on a new client that had a conflict with the scheduling of these meetings. It would drive me crazy before it would drive anybody else crazy.
Legislator Diamond.
Well, my town supervisor is on my back about this, so I'm interested in getting it resolved. I'm just not sure of the protocol. I mean, if this is part of the charter, then it should go in front of the whole committee. If it's something that we can do by resolution, I'd be willing to do that.
This has to be, it would be one of those changes that is subject to permissive referendum. And in drafting those changes to try and keep moving forward in a timely manner, I'd like to gauge the support of legislators present. And I understand there are 2 legislators absent, but we're pretty close to a committee of the whole. And with that in mind, I would like to gauge this so that we can move forward in drafting these changes that could be proposed and adopted by local law. And with that in mind, I guess I would, unless there's further discussion on this particular topic, like to take a straw poll of legislators. If you do not feel comfortable answering at this point, that's understandable. It's something that we're discussing and we're thinking through. But if it's something that you, one way or another, feel very much for or very much against, I'd like to just gauge that so we know whether there's 2/3 support or no support. I would like to treat it as a roll call, and it'll be a simple yes or no. Question being, shall the county attorney be allowed to represent other municipalities? Does everybody understand what I'm trying to get at?
Yep.
Are you actually taking notes, Cheryl?
No, this is completely informal. And,
Informal but formal.
well, informal, but I feel it's,
There's nothing wrong with expressing your opinion. I would not be opposed to something like that.
All right, we got Duke's approval.
so Legislator Kelly, Legislator Diamond,
I would support it.
Legislator DeChessie,
I would not be opposed to that.
Legislator Wheeler.
Yes.
Oh, Legislator B.
But was there a backroom deal or something?
Well, in Brian's defense, he was going from the agenda.
No, I'm
right?
sitting here quiet, maybe that's the reason why, yes.
Legislator Kuchas.
Absolutely.
Okay. And see, that's exactly what I like to do because we know that's something that we can draft in and it'll be part of the package and nobody will be shocked by it. Next question. There's only a couple more here. This, again, relates to the county attorney. The charter delineates currently that the attorney shall represent the legislature in a time of legal conflict. That is not to say a disagreement, but actual litigation. If this is the case, as the charter is written, that leaves the executive without counsel. And without the legislature appropriating funds for the executive to retain counsel, it would leave the executive without counsel. This is one of the NISAC changes.
I say yes.
Okay, I'll put you down. So the question would be, just to be clear, this is not a yes or no. In a time of conflict, shall the county attorney represent the executive or the legislature? Martin.
It should be the executive since it's his appointment.
Okay. Roy.
Executive.
Terry.
Executive.
Duke.
No, the way it is.
Okay.
So,
The executive.
The executive, because as you pointed out,
Yeah.
he represented us, and it was up to us to find an attorney for him.
we just.
We could just not pick one. But if we make him the executive's attorney, then now we no longer have the services available to us. We can,
And also
Yes.
taking the names away,
Exactly.
I don't want to offend Doug. The executive is the appointing authority for the attorney. And, you know, you could end up in a case where, you know, it just would be a messy situation. Okay.
You can look at it both, either we appoint the county attorney and he would represent us, or the county executive appoints the attorney and represent them. So I think there's two changes there, really,
Hmm.
my opinion.
Yeah. Well, I think that the situation can work the other way too, though, because the implication here is that the county attorney owing his appointment to the executive would show some loyalty there. But with respect to any potential disagreements that we would have as a legislative body, if that attorney was going to represent us in the end, then perhaps the loyalties, at least with respect to the issue, would go more toward the legislature. And so I think that's the theory behind that provision of the charter.
How did it work with the Gulf Pro? Did the city council?
It didn't work, it worked very well.
I gotta tell you, it's an interesting thing. Just, we're going through a lot of changes here, but, we're very quickly picking and choosing which executive authorities we want to support and which ones we don't. I see that coming. I see that coming with that appointment for oversight on the landfill closure. So I pretty much want to stick with the charter where I can when it comes to those kinds of things. And certainly the legislature has some authority too. And so I think that having the county attorney representing the legislative body, if a disagreement should come, I think is something that we're going to need.
Well, how would that change then, Duke? So you're not interested in the change?
Right.
So the county attorney would represent the legislature, so then would we need to
I think,
put something in place where the executive could hire his attorney? Because we control the purse strings.
do you see the interesting proposition that a county executive has when he's choosing an attorney, knowing that the attorney is not going to represent him if there's a problem between the two.
So
That causes, I think that causes an appointment that I think would be a good choice to get us to a point where we don't have conflict. And you're that guy, aren't you?
If I may.
Yeah, by all means. Treat it as an
At
open
this
discussion,
point,
please.
I'm not going to pick favorites in terms of picking one branch of the government that I would prefer to represent in this conflict situation, and I really don't have a personal preference at least at the moment. I can see both sides of this. Being that it is an executive appointment, even though it's subject to confirmation of the legislature does not select the name and put the name into play. It would seem logical to me from that perspective that the county attorney represent the executive in the event of such a conflict. However, given the language that's in the charter right now, which takes some digesting, because I don't think this is the way you would see it set up in the majority of cases, but there is language here that appears to give the executive, if you interpret it liberally, appears to give the executive the access anyway. It says, the sentence says, in such event of the conflict, nothing herein shall be construed to deny the county executive access to obtaining legal counsel at county expense. If you interpret that sentence broadly, it would indicate that the executive can go out and hire an attorney when there's a conflict here and the county attorney is representing the legislature, the bill is going to be submitted and the county's got to pay it.
It's an open-ended bill.
Yes, it is.
Does that,
I would change my vote based on that, but.
I would also like to acknowledge that we did transfer money to the, to have the county executive representative from a firm out in Syracuse.
That is certainly correct, yes. However, it hasn't been, let's put it this way, it hasn't been used, at least to my knowledge,
But
to date in the sense of a conflict.
Right. But he has that capability, correct?
Yes, there is, I believe there is a sum of money there, but yes, there is, certainly. What I'm saying from this, though, is the language in the charter would appear to give the executive access to go out and hire someone in the event of a conflict, whether it was that law firm or whatever it was, whether it was budgeted already or whether it wasn't.
now, as the legislative's main task of dealing with financial matters, if a bill were to come in for special counsel for the executive, and that were to be denied payment, wouldn't that just, would, let's see, I mean, would it be a nightmare? Yes. But would there be any mechanism to pay that bill no matter what?
Judge's orders.
And then you have another court case. And you're already, in this theory, you're already in.
It could go as far as that, but I would say that the charter could be interpreted to make that as long as the charges were deemed in the eyes of a reasonable person to be reasonable and not inflated and excessive, you could conceivably contest the amount of the bill, but to simply say we're not paying for the executive's attorney in this conflict situation that had arisen, I don't think you'd be on solid ground to say that. Could you, again, if you wanted to say, hey, these charges are excessive, you could fight that battle. But it would appear that the executive, by the language that's here now, it could be a little clearer than it is, but by the language that's here now, would have access to counsel without having to come to the legislature and say, hey guys, I'm fighting you on this matter and I need you to give me $10,000 or whatever.
Well, that's a good point, because the other side of the coin is that if the county attorney were to represent the executive, the legislative body has the ability to choose its own counsel and can determine the budget too for that at that time, so it might make it a little bit smoother. So maybe the changes could make sense.
And I do want to point out that this is something that NICEAG's going to be talking to us about. This was one of their highlighted changes that they, and I have it right in front of me, that, I'm just trying to see the exact language. I believe in here that they say that in general,
It's at the top of page 22.
most counties in a time of conflict shall represent the county and not the legislature. Additionally, and this is under an action item, additionally, the board may want to add that the legislature may also seek legal counsel at the county's expense. So this might be something that will come, this will be something that will come back up when Patrick Cumming and Steve Aquario come out, and they might be able to guide
I
us
see the
through.
value of that, because then the board can set its own budget for that, and,
Right.
And that's something that would prevent that
yeah.
appropriation
Right.
conflict.
Okay, so on your straw poll, I'm gonna change my position based on what I've heard.
Just so you're aware, that comment would appear to lead to the situation that was just referenced over here with regard to the city and the golf pro, because it appears to be saying that the county attorney shall represent the county. And in that sense, that's not the county executive, that's the county. And the upshot of this may be, you both gotta go out and hire separate attorneys.
Well, we're gonna get somebody good.
I think this might be something that we want to further discuss with NISAC, but it's, at least we're all thinking about it. The next, unless there's any other last comments on that, on county attorney?
The only thing I want to say is I actually went on the radio with 2 other supervisors and at length discussed this attorney issue. But this was a very heated thing. People didn't really want to look at the details of the charter. They just wanted to change. So this actually came up, and the fact that at one point 3 attorneys could be a potential, oh, they're lying, you're not telling us the truth. But it is the truth, because there were supervisors that actually read the charter in full, in detail. So this is wonderful that we're all talking about this.
Go ahead.
I will tell you this, there are counties, I can't tell you exactly how many, but there are counties that, and they're larger counties than this county is, but as a rule, proceed. Now, this would be a situation where the county attorney would be deemed to represent the executive in a conflict. They have on staff legislative counsel already, which is not the county attorney, but it's legal counsel to represent the legislature. It's already there. You're already paying for it on a whatever basis they have set. So I don't think you want to go in that direction, but that happens. I speak to numerous other county attorneys when I see them at gatherings and meetings, and sometimes just to questions back and forth, and there are a lot of variations.
Thank you.
Next sort of overarching topic, there's 2 large questions that have come to the forefront with basically every article of the charter. And basically it deals with department heads and their deputies. So the first question that I'm going to throw out there is, as of now, we have, I believe, only 1 position that is given educational requirements. So the question I'm going to throw out for discussion is, should there be educational requirements for elected and appointed officials as well as department heads? Obviously, we could go through this department at a time, but I'm treating this, and I guess I might be able to be convinced otherwise, but I think there should be a blanket policy that we could treat as a county, whether department heads and deputies have educational requirements. And then the question, which we don't have a clear answer on, we need to do some digging still, is elected officials, what would need to be done to give elected officials educational requirements? So with that, Legislator Wheeler.
I'm going to say no, because we don't have to, the elected official can have a high school diploma. If someone is a deputy or department head has 28, 24 years experience, I think it's all individual and to the merits of the person. And sometimes politics can get involved. So I would say no, as a blanket statement.
And let me just add this. It could be a yes, no, or you don't think it should be treated as a blanket statement.
Excuse me.
yes.
I don't get it. What are you talking about with elected officials?
There was a request sent in that, that there be an educational requirement for the county executive. And that's exactly why, that's why elected officials was included in this question.
Can I just, I'm sorry, I just wanted to add one last thing. Yeah, I think that education brings something to the table. I think adding it as a requirement does infringe. So my answer is still the same as I gave you.
Are there any other examples of that? Are there places that do that?
That I'm going to leave open for anybody to answer if they know of any elected officials that have educational requirements. There's obviously residency requirements with elected officials, but educational,
I've never heard of that. That's unheard of, isn't it?
Well, it's a judge, no. If you're
A
running
judge-
for a judge, that's an
Yes.
elected office,
Yes.
you have to
Supreme
have
Court.
the educational requirement, absolutely. There are elected offices where you have to have,
Well, we talked about this afternoon, and as I was driving back to Amsterdam, it occurred to me that with respect to the judges, or say the state attorney general, or somebody
Okay.
who's elected,
Yep.
that sort of thing, I don't believe it's phrased in the form of an educational requirement, but it says that you have to be a licensed practicing attorney in the state, and maybe for a minimum number of years. For Supreme Court happens to be 10 years. It's not, it doesn't say you have to have gone to law school. I think perhaps when you started, there was an Amsterdam city attorney who did not go to law school, who practiced very capably for many years, now not with us any longer. So it's
It's
not.
always been so hard to tell.
Huh? But I think that there are requirements that obviously, if you're going to be the Attorney General or you're going to be an elected judge, other than a town or village justice or the peace type of position, that you be a practicing attorney.
but I think that gives the merits to my case exactly. Where there was a city judge who held that position qualified, and then was either grandfathered in, or for whatever reason, I might be a little bit too young to have experienced that, but that I think gives merit to my answer.
As far as positions that don't require a professional license in order to hold them, I don't know of any. There may be.
Right.
I just learned of this afternoon, so I don't know as far as other county executives. That would be an interesting question. I'd
I
be
definitely
curious.
don't like that.
Okay. Now,
We get into the GPA next.
legislator Kelly.
I think it should be up to the people to decide if somebody is qualified or not.
So for elected officials, can we sort of, I guess I should split that maybe a little. Elected officials, no educational requirements other than those by,
What's the educational requirement to be governor of the state? The president. It's an age requirement.
I've never
But
heard
no.
of it. I've never
So
heard
why
of
are we
it
splitting?
before.
Yeah.
well, we haven't really discussed, appointed officials or department heads, whether there should be educational requirements. Now, keep in mind that any, the name slips me, the sheet from personnel officer, what's that?
Richard?
Well, yes, but the actual job description
Okay.
will have certain requirements. And, those for appointed officials as well as department heads would be in place. But the question that I pose to you all is, do we want to have those written into the charter that require amendment, or, if there were to be a change, an amendment by local law, Existing, and please point out if there's another one. Right now, our charter indicates that we need to have a purchasing agent with a bachelor's degree.
There is another.
Oh, Ken Rowe, or, excuse me, the Director of Economic Development and Planning. So there's two as of now. I tend to have the opinion that we should have a blanket policy, that it would be fair that, much fairer that way. That you're not taking favorites and you're not treating, you're not, applying a law to one person when their next door neighbor it's not applied to. With that in mind, again, I turn it over for any thoughts.
I like it.
So you're definitely in the no category. I got you in the no category.
Excellent.
Does that mean,
Yes.
does that mean eliminating the ones that do exist?
That would mean if it was the majority of the legislature's of I don't want to say opinion, but general gist of it that we wanted to move forward with no educational requirements, that would mean removing those two provisions from Director of Economic Development and Planning and Purchasing Agent. Now, if we were to go the opposite end of the spectrum, it would mean putting in educational requirements for everybody.
What about Department of Health? They have a requirement.
If I may.
Yep.
I was just thinking of that position. You have some level of insulation there, whether you want it or not, because when a director of public health is appointed, it is subject to review and confirmation by the State Department of Health. You can't just pick somebody off the street and put them in without the blessing of the State Department of Health. How much faith you have in them, that's up to you, but that is there.
I'm still disappointed in the flea flicker play called in the earlier game, so I'm just going to pass on the rest of this.
Okay.
Okay. All right. On that note, I personally think there should be some qualifications. Now, whether we deem that as more on the education side or more on experience, but you got to have a certain standard. I mean, you just can't hire, if you were in the private sector, there's qualifications, and you got to meet those qualifications.
Now,
Civil service too.
Pardon me?
Civil service positions, there is.
Right.
and this would not change those civil service
definitely not.
requirements or whatever the personnel department assigns as educational requirements.
It's just whether you
It
want
just
to
means
charter.
whether it's in the charter or not.
Oh, okay.
Those will, I would say most, I don't want to say all, but the majority of department heads would still have, at the end of that job description, certain eligibility requirements, which would be a combination of experience, typically is a combination of experience and education. Those would still be there, it just would not be written in the charter.
Okay, now I got you.
Is anyone, never mind. Can't hear that publicly.
Now we all want to know.
Might get into.
You're gonna like the next question I have, Duke. You're gonna like the next question I have.
So you're looking at basically saying that all department heads must possess a bachelor's degree at minimum?
Well, that would be the alternative to not having anything in there. Or we could pick and choose, if that's the feeling of, 2/3 of the legislature.
Do I like you? Can you say?
Well, so I'm thinking some future county executive decides he's gonna hire his 18-year-old dropout, lazy bum.
But then it's up to the legislature
To not confirm.
to not confirm.
Right.
There is a check and balance.
But you also might have somebody that has 25 years of really good experience and has proven themselves and doesn't have a high school diploma.
Right.
You have both sides of
Get
it.
in the business.
You do have the backup from the Department of Personnel, and you've got to sort of rely on those checks and balances and public oversight to say you're not just appointing your cronies, you know, your buddies to.
Well, I
Pardon?
think it's kind of two things. The executive has his appointments and we have ours, so the executive will set his requirements and we should set ours. As far as ours, like, we only have a few appointments, like county auditor. I would probably want someone with an accounting background or a degree in accounting or public administration, something like that, for ours. For the executive, it would be up to him, I would say. That's my opinion.
Cheryl, you might be going back to school.
No, I would grandfather Cheryl.
Next question.
New appointment.
And this one is gonna be, you know, I just wanna throw it out there to start the discussion. It's something that I found in other county charters, was not expecting to find. Residency requirements. Just to get everybody to start thinking, there are other county charters that supersede New York State Public Officers Law, saying that, I'm just going to use one example off the top of my head, the Putnam County Charter. Their Commissioner of Highways and Facilities can live within 50 linear miles of the highway building. My point in what's that?
Can or shall?
Must.
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 Can or shall.
It opens up the discussion that was brought up earlier this year with Public Officers Law of a blanket policy that cannot be done at the state level, but because we are a charter form of government, can be done at the local level at this point. Is it something that anybody wants to explore? And you know, there's very much so nowadays a regional context debate. We live in a very sort of regionally cohesive area. This is something that we could incorporate, we could not incorporate. But again, it would be, I think, only fair to do it as a blanket policy. Throwing it out there for discussion and thoughts.
Let's chew on it.
Do you want to leave that one to chew?
Excuse me, I get a bit.
I don't.
Why don't we just mention the other possibility?
The last thing, so we'll leave that.
Well, I mean, the idea of the contiguous, just as so that people have that in their heads to possibly think about.
Okay, yes.
See you Saturday.
Is that, it's up to you, Bud.
So, you know, one possibility would be adjoining adjacent counties, which would be Herkimer,
Yeah, bordering counties.
bordering counties.
Love it.
Which means if you live, you know, right across the line in the town, I'm not gonna proceed down that route.
Just so you know, that bordering counties would also include Saratoga and Schenectady County.
There are 6.
Otsego.
Otsego, Scutari, Schenectady,
Saratoga,
Saratoga,
Fulton,
Fulton, and
Herkimer.
Herkimer.
Yep.
So there's 6 adjoining counties, adjacent counties. It's something that we could,
Landlocked.
it's something that we could put in there. But again, you know, it's sort of just throwing out there as an option. I thought it was a unique option that I wasn't expecting to see, but I think it has some merit that it's a, you know, it has that blanket policy fairness.
As a former school district employee, I saw the school districts actually getting away from the residency requirements because it narrowed their pool, obviously, for superintendents of schools. And also, I even think business managers, off the top of my head, I know the business manager for Brown Perk lives in Tribes Hill. So, you know, I think even the school districts know it's hard just to hire within their own boundaries, so I'm in favor of expanding it.
Excellent.
I'm in favor of expanding it, but I don't know if I'd go with the entire counties. Maybe that 50 linear mile thing is a good idea.
That's farther.
Was further.
That would be
That's
like
farther.
Greenwich. You'd almost be in the Massachusetts
That's a
line.
straight
Then I would
Utica.
support the surrounding counties.
And remember, that's straight line, and given the rectangular shape of our county, since it would be the county seat, you'd have more applicants from Fulton, Schoharie, Schenectady County opposed to Herkimer or parts of Schenectady and Saratoga County. So it would, doing that, I mean, you could probably word it, figure out a way to word it, but that was, the 50 linear miles is, it goes west of Utica, almost to the Massachusetts line, and it
Okay.
covers Blue Mountain Lake, large area. Legislator Kelly,
As much as I'd like to leave.
there's only one other question
Okay.
after this. Should be short too.
I understand that we want to expand our pool of potentially new people. But at the same time, don't we want employees who are invested into our county? I don't know, have some stake in the game?
Very good point. Any other thoughts at the moment?
I agree with that, but I hate to limit ourselves. I'm wondering if the wording can be to the effect that we will make every effort for the position to be a resident. However, if we are unable to find a qualified candidate, then we can go to the surrounding counties.
If it's possibly if it's a position that requires certain qualifications that may be harder to come by in a limited
Yes.
pool, you could open that up.
Yeah.
I see where you're going with that. Okay. So definitely, I think needs some more thought on our parts and more discussion in the future.
Yeah, I just want to say, I really respect the work you put into this. I mean, and I don't mean this in the wrong way, but it may be a little bit too comprehensive. We may need a little, no, there are certainly, there are issues where the charter is not clear, issues where the charter may be in conflict with other parts of it. And I think that's what should drive this process in the initial stages, rather than trying to undo any potential wrong you see down the road, and coming up with all these different scenarios and circumstances. So I think prioritizing the change that we want to make this time out, and I think would be of some value to us. Because, as for instance, the arguments with respect to residency, they're really well defined. Everybody knows what they are, the pros and the cons. And so, that's something we can toss around and have a pitched battle over. But I think our focus right now should be on those areas of the charter that really need resolution, that really need, where the conflict has to be solved, and where there are problems.
Absolutely, and I appreciate that. It just came up with the educational, we received comments with educational requirements, and it just stirred the debate,
Yeah, that was particularly novel, I thought.
So, and the last thing, and this won't take much debate, with the charter and local law process that requires 10 days of a local law sitting at our desk before it's voted upon. If a local law is introduced to us on the third Tuesday, let's say on personnel, education, government, or finance, whatever committee might meet, at that point, there's not a 10-day period until the full board meeting. With that in mind, and this is something that came up this afternoon, the thought of moving committee meetings to the first and second Tuesdays of the month both back, and then having the third Tuesday open possibly for committee of the whole, special meetings, and then the regular meeting on the 4th. So it would be first, second, blank, 4th.
I love it, it's a great idea. Perfect.
And that would just be, this is something that can be changed by, yeah, let's do it.
Super.
So it's, it's an informal policy that we follow, that it's the second and third Tuesdays.
Why
Yes.
can't we just change the 10 days to 7?
That's by charter.
Well, even with 7, you would have to do that memo of necessity. So we would eliminate.
Yeah, because Sundays don't count.
Yeah, and the day.
And the day that you introduce it doesn't count, so the 1 week, it wouldn't fly with 1 week prior to the meeting for that. It's not an insurmountable problem, don't get me wrong, but they're just, if it came out at the third Tuesday.
One of the 4 examples is why this came up this afternoon is next month, Sean has submitted 2 or 3 local laws that we need to entertain for property transfers, for county-owned property being transferred. If it's entertained at the Finance Committee in May, we won't meet the requirement to do the local law. So we either have to move it to the first or second.
Can I just make a suggestion in regard to that? That particular issue with those properties, they are now county-owned properties upon which the county's foreclosed by virtue of their foreclosure proceeding that we just finished. Why don't you put them on the Physical Services Committee
Okay,
for
next
May?
month.
Whether you do that forever or not, but for this particular instance, so as not to delay it, and do it that way for that, and then assuming they pass, there'll be plenty of time.
Any thoughts, significant conflicts, keep it as is and work with it as best as possible. If we know there's a local law, put it on the second.
Pretty much, we should know what they're coming down the pike. And if we don't, there's nothing, it's a sense of urgency. Please, Matt.
While we were trying to clean this up today, when you think about it, this situation, as far as the legislature is concerned, is really no more time consuming than the old system, because with the old system, the Board of Supervisors would adopt a resolution through committee at, say, the April meeting to schedule a public hearing on a local law for the May meeting, and it would sit there for 30 days or thereabouts and then be voted on. So you haven't really lost that much time, except that now you have the requirement that it goes to the executive after the. But if you don't want to change the meetings, probably the better.
First Tuesday.
Okay.
Oh, okay.
You what?
That's why if we can just juggle when we schedule these
Okay.
things.
We can, I mean, the
Yeah,
only
and we
other
can-
local laws that we would possibly be entertaining would be coming from Sean, which would be finance, or we move it to a different committee, if we
Right.
know ahead of time.
Okay, that sounds
Let's
good.
move all the committees I sit on the second Tuesday.
Any other topics of discussion?
I'm
No.
gonna go with that.
Nothing.
No other topics of discussion? I would
Motion adjourned.
entertain a motion to adjourn.
Second.
Martin, seconded
Sweet.
by Barbara, all in favor?
Aye.
Thank you very much. I really appreciate it.
Get your taxes done, people, if you have them. Tax day.